Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. Guys, I don't give legal advice. As you know, this is only for entertainment purposes only. Let's talk about a case that we're watching closely. This is Marlon Lewis's case. If you want to follow it, you can look at it online. It's right here, case number 24-06-09540, and the website is odyssey.mctx.org, where you would be able to log in as a guest and take a look. And you can see his quiet title action is there. It was filed on June 20th, and you can see that the other side filed a response right here. Defendant's answer to plaintiff's quiet title action. I'm surprised they did not file a motion to dismiss, which is what they normally do. Okay, and you can see they basically deny everything. Don't even have to go through it because they just pretty much deny everything on every single question. So, denied, or they're barred. So, this is what they do when they file an answer. They just deny everything. There we go. Wherefore, the defendants respectfully request that this court enter judgment that plaintiff take nothing by this suit and or dismiss plaintiff's claims with prejudice against the defendants and award defendant all further relief to which defendants may show itself entitled. And this attorney's firm is representing both of the defendants, SN Servicing and U.S. Bank. As you can see, defendants, SN Servicing Corporation and U.S. Bank Association as trustee of the Igloo Series V Trust. Collectively, defendants file this answer. So it's interesting that they are both being represented by the same attorney's firm. Anyway, so let's see, what is Marlon going to do next? He's going to file an amended complaint. What's he going to do? Let's take a look at that, what that looks like. Okay. Alright, so let's look at his amended complaint. Okay, here it is. It's going to be in the same court with the same case number, same people, and the caption on the first page says, motion for leave to file an amended complaint with proposed first amended complaint. Okay, so here he is saying he's going to file an amended complaint. Okay, and then table of contents, parties, jurisdiction and venue, introduction, factual allegations, defects exist in the chain of title, defective promissory note, payment history discrepancies, predatory loan modification agreement, defendant violated Texas foreclosure statute, defendant violated paragraph 22 of the deed of trust, causes of action, count 1 fraud, count 2 Federal Debt Collection Practices Act, count 3 slander of title, count 4 breach of contract, count 5 RESPA violation, count 6 truth in lending, count 7 unjust enrichment, count 8 wrongful foreclosure. Conclusion, prayer for relief and exhibits. This is quite a complaint, as you can see. So he basically goes over the parties, the jurisdiction, and goes over the introduction here. As you can see, these bullet points right here. Servicers insufficient response to RESPA letters asking for clarification, payment history with errors and omissions, filing defective assignments of deed of trust, tricking plaintiff to sign a predatory loan modification, servicer's failure to apply Chapter 13 payments correctly to the loan, mailing the plaintiff letters which have contradicting information, attempting to illegally foreclose by using the power of sale in which defendant lacks the legal right to enforce. Okay, and then this complaint will outline not just how the plaintiff has been harmed by the servicer, but will also provide evidence by exhibits which substantiate these claims. Okay, we have a nice little footnote here about filing an amendment, which is what he's going to do. Factual allegations. Now this is going to be long, guys. If you have any questions or you want to see a copy of the complaint, you can send me a request, and I'll be happy to share some of this with you guys, because it's important that we all share what works. Anyway, he's got a long list of exhibits attached to each of his allegations. He goes over the defects in the chain of title here, defective promissory note stuff here, payment history discrepancies here, predatory loan modification agreement here, we go over they violated Texas foreclosure statute. They didn't follow the rules where they're supposed to publish it in the newspaper so many weeks before the sale. They didn't do that. So we go over that and that, which is the law. And they violated paragraph 22 of the deed of trust, which talks about acceleration and how they're supposed to follow what's written in there, which they didn't do. And then we go to the first cause of action, which is fraud. Again, we have to go over each of the elements. For instance, a representation, SN Servicing and its predecessors failed to properly apply payments to the plaintiff's loan. And other things, we can go through each one, but it'll take a really long time, guys, and I know you want these videos to be fairly short. But like I said, if you want to read some of these, feel free to ask. Count 2, FDCPA, we go over all those violations and the slander of the title. Let's go to the information that we are added that was new, which is wrongful foreclosure. That's this one here. Count 8. Now, on July 2nd, 2024, which was a couple of days ago, defendant foreclosed on the plaintiff's property unlawfully. To establish a wrongful foreclosure claim when a valid complaint list pendants were ignored, the elements are as follows. On June 20th, 2024, plaintiff filed a valid complaint on the 284th Judicial District Court in Montgomery County, Texas. There's the claim number, the case number. On June 20th, plaintiff recorded a lis pendens, which puts the world on notice of this pending litigation. The defendant had actual knowledge of the complaint lis pendens by the receipt of letters which were mailed on June 21st and June 26th, Exhibits P and Q. The defendant does not have clear legal standing or authority to foreclose. The defendant did not follow proper guidelines that the notice must be published weekly for 3 consecutive weeks in a local newspaper, general circulation in the county where the property is located. The trustee's sale proceeded despite this knowledge. See copy of email from George Shearer, Exhibit R. The plaintiff has suffered damages by the defendant by wrongfully foreclosing on his home. Conclusion. Defendants, U.S. Bank and SN Servicing has wrongfully foreclosed on the plaintiff's home. Plaintiff has been harmed by many years by defendant's actions. Payments were never properly credited to the loan. Plaintiff was tricked into getting a predatory loan modification with hidden balloon payment, which was never fully explained. Defendant never properly credited his principal balance when he was in Chapter 13 bankruptcy, and plaintiff was charged unauthorized fees. The amount listed on the acceleration notice was incorrect. Despite all of this, the defendant lacks proper assignment of the deed of trust and proper assignment of the note. Defendant, U.S. Bank and its purported trust, has sustained no injury. A claim of default is not a claim of injury if the entity is not the rightful owner or person entitled to enforce. In Texas, the mortgage servicer or trustee must have the legal authority to exercise the power of sale clause in the deed of trust. Both SN Servicing and U.S. Bank lack rights to enforce the deed of trust. There is no loan or contract that exists between the plaintiff and defendants. Defendants have violated FDCPA, res, patiller, and Texas law. U.S. Bank Trust Pooling and Servicing Agreement requires that the trust must have actual possession of the original loan documents by the closing date of the trust, or it cannot own the loan. If the trust cannot demonstrate that it is in possession of the original documents pursuant to the terms of the PSA, then it does not own the loan and it cannot enforce the mortgage or the note against the homeowner. It is doubtful the loan was cherry-picked out of the trust pool and placed into another trust pool. This trust had no legal standing to foreclose, wherefore plaintiff's only option is to quiet title to the property and make defendants accountable for their actions in violating both federal and state laws. And then he has his prayer for relief here, which also includes reversing the foreclosure sale, as you see. So he's asking this for his prayer for relief, guys. Okay, well, I thought you guys would get some understanding by going over this. I hope everyone has a fantastic day, and if you have questions, you can send me an email to foreclosurehelp777@gmail.com. And I hope you subscribe to my channel. Every little bit helps, guys. So thank you very much, and everyone have a blessed day.